Guys, what's up? Welcome back to the channel. So today, the topic of discussion, we're going to be discussing the feds, or the AUSA, I believe you call them, the prosecutors on the Little Durk case, and their response to the bond reconsiderations that they are going to take place or be part of here in the near future. I don't know the exact date, but it's coming up. So without further ado, let's get to this content. I got this from Seti Nash's page. You guys go follow him. I'll link his video in the description. Let's listen to what the feds have to say about this, and then let's react to it.
All right, man, here we go. So this is Durk right here. This is government's opposition to defendant's bank's application for reconsider of detention order. So we ain't even finna read all this stuff. You already know what they talking about. We finna oppose him getting out. And here's what they said. Memorandum of Points and Authorities Introduction. Defendant is charged with directing 6 hitmen to travel across the country to hunt and kill his rival, TB. That's Quando Rondo. Defendant allegedly orchestrated and financed the brazen murder plot that culminated with shooters ambushing TB's vehicle at a busy gas station in broad daylight, killing SR. That's Lil Pop. Following a detention hearing in December 2024, the court ordered defendant detained based on flight risk and ongoing danger. Pay attention to that ongoing danger part. They ain't put that in there for no reason. It reasoned that no conditions of release would reasonably assure the safety of the community, finding that defendant uses his money, influence, and power to endanger individuals whom he perceives as a threat. DTK 116 at 4. The court also found that defendant was a flight risk based on his attempt to flee the country immediately after learning of his co-conspirator's arrest. Defendant now seeks reconsideration of that order. But defendant's application fails to address, and I said this before, y'all, any facts that the court relied on when it made its flight risk and danger findings, and fails to present information that was not known to defendant at the time of the hearing and that has a material bearing on its dangerousness in flight. 18 U.S.C. 3142 F2 emphasis added. Instead, he offers essentially the same bond package the court already rejected and seeks to relitigate an immaterial issue about when certain of his violent rap lyrics were written. Indeed, the crux of defendant's application is that he did write lyrics about greenlighting someone's murder, just that it wasn't this murder. But, man, whatever, okay. But the timing of defendant's lyrics and whether or not he commercialized his violence to rap, which he did, has little to no bearing on the detention analysis before the court. The issue here is a narrow one. Has defendant presented new information not known to him in December 2024 that has a material bearing on whether he should be detained pending trial? The answer is no. The government respectfully requests that this court summarily deny defendant's application for reconsideration. Background. The indictment and defendant's attempt to flee. On October 17, 2024, a grand jury sitting in the Central District Court of California returned an indictment charging five of defendant's co-conspirators with crimes arising from the murder. So what happened to the sixth one? Including murder for hire and conspiracy to commit murder for hire resulting in death in violation of 18 U.S.C. 1958A. CDKT. Defendant was identified as co-conspirator 1 throughout the indictment, which listed defendant's involvement in the murder scheme, including the allegation that he told co-conspirators that he would pay a bounty for TB's murder. CID at Overt Act 1. In the early hours of October 24, 2024, federal and local law enforcement executed multiple search warrants at locations associated with members of defendant's organization, Only the Family, or OTF, in the Chicago area and arrested the 5 charged co-conspirators. Soon after law enforcement executed the warrants, the FBI learned that defendant had been booked on 3 international flights, including at least one to a non-extradition country. Defendant skipped the first 2 flights and was arrested when he showed up to board a private jet scheduled to leave the United States a short time after. ID at 9 through 10. On November 7, 2024, the grand jury returned the first superseding indictment, FS1, or FSI, against defendant and his co-conspirators. The FSI identified defendant as co-conspirator 1 and alleged that he formed and was the leader of OTF, a group of individuals who engaged in violence, including murder and assault, at the direction of defendant banks and to maintain their status in OTF. ID at introductory allegation 1. The FSI also included an allegation that defendant commercialized his violence through rap lyrics. Defendant is ordered detained. In December 2024, the court held a detention hearing and considered evidence and arguments submitted by the parties. Among other things, defendant made the same argument he now raises in his application to reopen, a claim that the lyrics cited in an introductory allegation in the FSI about greenlighting violence could not be about SR murders because defendant wrote the lyrics before the murder occurred. During the hearing, the court addressed the matter, finding that the consistency and timing of the lyrics has some relevance, but marginal to the dangerousness issue, which is the issue before me today. After considering the evidence, the court ordered defendant detained based on flight risk and ongoing danger to the community. The court subsequently issued a thorough written detention order. As to danger, the court detailed the allegations against defendant, including the co-conspirators acting at defendant's direction, traveled to Los Angeles, tracked, stalked, and attempted to kill TB by gunfire, including a fully automatic firearm in broad daylight in a busy Los Angeles intersection, and did kill a family member of the target who was traveling with him. The court also relied on evidence that this was not defendant's first murder-for-hire plot, noting, in a separate matter in Chicago, defendant is alleged to have engaged in a similar conduct. That is, the offered money for people to kill those responsible for his brother's murder, and more specifically, offering to pay money for any gangster disciple that is killed. That's not even true, though, because he had a couple of GDs signed to him. That doesn't even make sense, but whatever. As a result, the court found the material proffered by the government supports the conclusion that defendant uses his money, influence, and power to endanger individuals whom he perceives as a threat. Government's detention brief, example 2, under seal at 12:14 through 15. As to flight, the court rejected the argument that defendant's significant bond package mitigated his risk of non-appearance. Among other things, the court found that defendant attempted to leave the United States upon learning of the arrest of his co-conspirators. Argument: defendant's application fails to offer any new evidence, much less evidence that is material to the detention analysis. A detention hearing may be reported only if the judicial officer finds that information exists that was not known to the movant at the time of the hearing and that has a material bearing on the issue, whether there are conditions of release that will reasonably assure that appearance of such person as required and the safety of any other person and the community. 18 U.S.C. 3142 F2 emphasis added. Courts have interpreted this provision strictly, holding that hearings should not be reopened if the evidence was available at the time of the initial hearing. See United States versus Dillon, and then per claim affirming district court's refusal to we ain't finna do all that. Here we go right here. As to materiality, to open a detention hearing, a defendant must proffer evidence that, if true, affects the outcome of the court's pretrial detention inquiry. Here, defendant's only proffer of new information is that viral video, which overlaid the news clip of SR's death on top of the defendant's songs, including lyrics about greenlighting a murder, were made by defendant's fans, some of which have millions of views, not defendant. But defendant's claim about the timing of his rap lyrics and the fan-made videos is neither new nor does it have a material bearing on the court's detention analysis. Tellingly, defendant's application does not even reference the court's analysis on danger or flight. It actually does, though. But you just lied, but that's, y'all do that. It does not explain how defendant's lyrics or fan-made videos undermine the interference that defendant, who has considerable resources, attempted to leave the United States upon learning of the arrest of his co-conspirators, or that defendant uses his money, influence, and power to endanger individuals whom he perceives as a threat. Nor could it. At the hearing, defense counsel raised the exact issue of timing of defendant's lyrics. The court made clear that the lyrics were not material to his detention analysis. So Durk gonna try to have that knocked out there. He'll try to throw that away, because if you're saying that that's not even material, like that's not important, then Durk gonna say, then why bring it up? So here you go. The lack of materiality is confirmed by the court's oral and written explanation of his detention order, neither of which considers or even mentions defendant's lyrics or the above referenced videos. We're gonna go back to right here, and it says CEG, Lil Durk, Dis Quando Rondo, a new song, and then it says Lil Durk, King Von, Quando Rondo available, and then it shows the YouTube video, and the lyrics defendant challenges are contained in paragraph 6. So basically, they're just showing the YouTube video. So they didn't even reference the YouTube video in Drew Finland stuff. So yeah. Moreover, defendant's proffer that his fans, rather than defendant himself, created the video linking him to SR's murder is immaterial to defendant's danger or fight. Defendant was not detained because of videos his fans created. He was detained because he is alleged to be the leader of a violent organization, because he orchestrated and funded an execution-style murder with machine guns at a busy gas station, and because he tried to flee the country after his co-conspirators were arrested. But that's not okay. Drew gonna argue this, but I'll kind of explain it a little bit. But even if the lyrics or the videos had some bearing on the detention analysis, they corroborate defendant's danger. Defendant has repeatedly used his pulpit as a voice of violence, publicly rapped about paying for murders, hunting opponents with machine guns, bounty hunters in Beverly Hills, and other lyrics that have a striking similarity to the modus operandi. operandi, I'm sorry. Yeah, to the modus operandi used to kill SR. As the court found in ordering defendant's detention, defendant uses his money, influence, and power to endanger individuals whom he perceives as a threat. Defendant is wrong to suggest he is charged. For example, defendant was featured on another artist's song in which he raps, "I don't want no niggas who you catch. I want the one I paid for. Trolling ass, we shot your homie. Gucci Mane." Rumors. In this case, or is being detained pending trial because of his lyrics. It's true that words have power, and defendant's words about greenlighting violence and placing bounties may be admissions of criminal conduct. That is for a jury to decide. But this case is not about how defendant made his money. It is about how he allegedly chose to spend his money and wield his power in August 2022 on death and violence. Conclusion. For the foregoing reasons, the government respectfully requests that this court deny the application and maintain its order detaining defendant pending trial in this matter.
Okay, so there's a lot to unfold there. For one, let's just go ahead and say I personally believe that the feds play a dirty game. We all know this. We all know how the legal system works. Now, I'm not saying all of them are, but I have to get that off my chest because I'm seeing the way that they're coming for these artists and the mind games and the tactics that they do to essentially go ahead and either get a conviction, let them plea out, whatever. I'm not saying that I feel bad for them because they're locked up. That's not what I'm saying. I'm saying I feel bad for them for the way that these prosecutors are playing games, okay? Because if this happened to me personally and I was in their situation, I'd be going crazy. Imagine that. Let's just think about this. You're in jail fighting for your life. Again, obviously if you're in there for a reason, because you know what you've done in this, then it is what it is. You just have to sit there and take it. Now, if that's happening and the DA is coming at you on some bullshit, excuse my language, then guys, at that point, just imagine what these guys can go through. Now, I'm going to transition that. Again, Lil Durk is in here on a murder for hire. And I believe it's a life sentence in the feds. Anything that has to do with that is a life sentence. So he's in there, he's fighting this case, and basically the feds are saying that they're trying to fight against the fact that he basically was trying, they named a couple things. First of all, his music. Again, I think this is ludicrous when they use people's music. Now, again, if it's something where it's like, oh, I killed this dude in the back of Dunkin' Donuts, if that's what I rapped about, and then I actually did it, like specifically, that's different. But the vagueness of the lyrics and the fact that it can be, used for anything, it can be interpreted any type of way, essentially. So those are two different things, but they're listing his lyrics. They're also listing the fact that when after the concert that he performed in Florida, excuse my language, after the concert that he performed in Florida, he booked flights and was trying to get away. So they're saying a lot of stuff here. Drew Findlin, his lawyer here in Atlanta, is arguing that, you guys took his phone. You guys took his phone, so he knew this was coming, which, I don't know, to me personally, I feel like that's a weak argument. What I mean by that is, he obviously didn't know that they were coming, in my point of view. Why do I say that? When his co-defendants that are on this case got booked, that's when he booked multiple different flights to different areas. I don't know where exactly it was, but he booked a couple flights. I believe it was like 3 flights. And so when they took his phone, he didn't do anything. But again, maybe I'm reading into this wrong. I don't know. You guys tell me. What do you guys think? What do you guys think of the paperwork that the feds are doing? Man, they're listing everything. And let me tell you, feds and the state, 2 different factions completely. Obviously, you guys know that, but the Fed is just so much more intense because it's essentially the last line. You know what I mean? Like, if they're coming to get you, it's because you're doing something that is on the radar. So they cross their T's and dot their I's, I believe is the phrase. Anyways, guys, like I said, what do you guys think about this? Like, comment, subscribe. Shout out to Seti with the content. Seti Nash, you guys go follow him. He's actually one of the reasons why I started doing YouTube. You know, he inspired me. So what do you guys think about Durk? Again, these are the things they're listing. Now let's talk about this before we head off. I personally do not think he's going to get a bond. I feel like they're going to provide an argument in front of the judge that's going to be very, if this is what they're showing the public, imagine what they got cooked for the judge. So I don't see him coming out, but let's remain hopeful. We'll see what happens. Guys, I'm going to keep you updated on this case. Lock in, subscribe, comment. Let me know what you guys think, what's going to happen. We're going up content daily, guys. Love you.